When Rome expelled its kings, it gave itself a powerful word for freedom. The word was libertas, liberty, and at first it meant something quite particular. No king stood above the city. No royal household was to turn Rome into its private possession. Power at the top was shared between annual magistrates rather than held for life by one family. That was a real change, and it did not answer every question a citizen might ask when he came home from war and found a creditor waiting at his door. That is where this episode begins. A Roman citizen could belong to the Republic, answer the levy, march with shield and spear, and still come home to a farm in trouble. Crops might have gone untended while he was away, tools might have been sold or pawned, a loan might have grown heavier. A family that had served the city could discover that public liberty did not protect it from private vulnerability. Freedom from kings was one thing, protection inside the Republic was another. The episode asks 5 questions. What can safely be known about the early struggle between patricians and plebeians? Why did debt and military service make such pressure inside the young Republic? How did the tribunes and the plebeian council give citizens a new form of protection? Why did written law matter if the 12 tables were harsh and narrow? And what did this struggle do to the meaning of Roman citizenship before Rome began spreading its power outward across Italy? The first answer is caution. Later Romans called this long internal conflict the struggle of the orders. The phrase means the struggle between patricians, the old elite families who claimed special prestige and access to the highest offices, and plebeians, the citizens outside that patrician order. But the words can mislead if they are worn as simple labels. The plebs was no uniform poor class. It held destitute rural laborers and small farmers, artisans, and wealthy families who lacked patrician status, but wanted the same offices and honors. The patricians were powerful, and the boundary between the orders seems to have hardened over time rather than standing from the beginning as a fixed wall. That matters because the 5th century BC is one of the darkest stretches of Roman history. The full account survived through writers who lived centuries later, and those writers often arranged early conflict into a cleaner pattern than the evidence deserves. Later analysts explained too many early Roman developments in the same repeated terms. Plebeians press, patricians resist, crisis erupts, compromise follows. The outline of the struggle is usable. The details are open to question. The caution should not empty the account. Later Romans did not invent anxiety out of nothing. There were real pressure points in the early Republic: debt and hunger, land, military service, unequal access to office, and unequal access to legal knowledge. The tradition is too shaped to be read as a diary, but it preserves the memory of a republic that had removed kings without yet deciding how ordinary citizens could claim protection from other forms of power. Debt is the best place to see the problem. In a small farming society, debt did not live only in accounts and numbers. It lived in fields and seed grain, animals and tools, dowries, sons, fathers, and the power of a household to survive the next season. If a citizen was summoned to war, his service was public and honorable, but his land did not work itself while he was away. A campaign could mean damaged crops, missed labor, borrowed grain, and obligations that went on growing even while the soldier was serving the state. The Roman tradition returns again and again to the figure of the indebted citizen soldier. Every scene need not be accepted literally for its weight to be understood. The image worked because it laid bare a contradiction inside republican life. Rome needed citizens to fight, and those same citizens could be ruined by the cost of fighting. The state could call a man to defend liberty and then leave him exposed to a creditor when he returned. One term makes the pressure more concrete: nexum, the bond. It was a debt arrangement in which a debtor could make himself, or sometimes his dependents, personally liable to service if the debt was not cleared. The early Roman law of debt could look severe indeed: bondage, forced service, public humiliation, sale beyond Roman territory, and other terrifying remedies preserved in the legal tradition. The point is not a catalogue of punishments. The point is that debt could reach the body, and not only the purse. That fact changes the meaning of liberty. A citizen who feared debt bondage did not experience freedom as an abstract constitutional slogan. He experienced it as a question whether the Republic could protect his household from a creditor, a magistrate, or a powerful patron. Early Roman politics was not only an argument about offices. For many citizens, it was an argument about survival. Nor did the pressure come from debt alone. Famine and shortage of food appear repeatedly in the tradition, and the 5th century seems to show the marks of economic downturn. Land mattered, because small farmers needed ground enough to support households and serve in the citizen army. Legal knowledge mattered, because procedure could decide whether a citizen could defend himself. Political access mattered, because wealthy plebeians wanted high office and public standing. The struggle of the orders was therefore no single simple quarrel. It was a set of overlapping pressures that later Romans compressed into one long contest. This is why secession became so powerful a memory. Secession means withdrawal. In the Roman tradition, the plebs withdrew from Rome and refused its normal role until its demands were heard. The best-known version places the first secession in 494 BC at the Sacred Mount, a hill outside the city. Other traditions and later episodes point to the Aventine or the Janiculum. The exact place and the detailed speeches are not secure. What matters is the political idea. Citizens who lacked command could still remove their bodies, their labor, and their military service from the Republic. That leverage worked because Rome had no professional standing army in the later imperial sense. Its defense rested on citizens called from households and fields. If great numbers of plebeian citizens refused to serve, Rome lay open. The patricians might hold prestige and office. They could not defend the city alone. Withdrawal laid bare the dependence that elite authority preferred not to name. The secession memory is therefore no mere crowd scene. It is a lesson about the Republic's material body. The city needed farmers and soldiers, laborers, clients, debtors, and smallholders. It needed the people whose grievances were easy to postpone until their absence became dangerous. In the Roman imagination, plebeian withdrawal forced the ruling order to see that the Republic could not command citizens forever without giving them some recognized protection. Out of that remembered pressure came the tribunes of the plebs. A tribune was an officer of the plebeians, not a consul, not a king, and not a general by the nature of the office. The origin is uncertain, but the office became one of Rome's great political inventions. Its purpose was intervention. A tribune could step between a threatened plebeian and a magistrate. He could block action. He could say, in effect, that command had reached a limit. The Roman word most bound to that blocking power is veto, I forbid. Another is intercessio, intervention, the stepping between. The tribune's power did not begin as a twin of consular command. It was defensive, obstructive, protective, and that made it unusual. The early republic had already made magistrates who could command citizens. The tribunate made officers whose whole identity rested on protecting citizens against command. Tribunes were also sacrosanct, and the word means more than respected. In the Roman tradition, the plebeians swore an oath to protect their tribunes, and whoever harmed a tribune stood under religious and communal danger. Sacrosanctity made the tribune's body politically charged. He could intervene because the plebs had made him untouchable in a particular sense. That sacred protection gave weight to an office that rested neither on royal command nor on patrician prestige. In time, the number of tribunes settled at 10. The plebeians had also a council, the concilium plebis, and plebeian aediles, officers joined to plebeian affairs. This is why historians sometimes speak of a plebeian state within the Roman state. The phrase should be held carefully. It does not mean a separate country. It means that the plebeians built recognized offices, meetings, and decisions of their own inside the wider republic. The plebeian council mattered because Rome's people never acted as one flat mass of equal voters. Roman citizens voted in groups. In the Century 8 assembly, the voting units were tied to military and property ranking, and the wealthier groups carried an enormous structural advantage. The richer units could reach a majority before the poorer citizens had voted at all. That is not modern one-person, one-vote democracy. It is a weighted civic order. The tribal assembly and the plebeian council worked otherwise. They used tribes, which were divisions of geography, not ethnic tribes in the modern sense. By the later republic there were 35, 4 urban and 31 rural. The plebeian council excluded patricians and elected the plebeian officers, the tribunes among them. Its decisions were called plebiscites, from the Latin for decisions of the plebs. At first, plebiscites did not of themselves bind the whole Roman people as later laws did. Their force grew with time. That slow growth matters more than any single tidy date. Later tradition marked 287 BC and the Hortensian Law as the point when plebiscites became binding on the whole community, patricians included, and treated it as the formal end of the struggle of the orders. It should not be called a triumph of democracy. Wealth still mattered. Rich plebeians often gained more than poor ones. The council itself could be steered by its better-off members. Still, a plebeian institution had moved into the legal machinery of the whole state. The next question is why written law mattered. At first hearing, the writing down of law can sound dry, almost clerical. In early Rome it was much more. A citizen who did not know the rule, the proper words, the correct day, or the correct procedure depended on those who claimed to know them for him. If law lived mainly in elite memory, priestly expertise, and unwritten custom, then ordinary citizens could be free of kings and still dependent on the keepers of the rules. The priests who matter most here were the pontiffs, and they were not religious figures only in the narrow modern sense. In early Rome, religious time, public procedure, legal knowledge, and civic authority overlapped. Early Roman civil law and legal procedure were closely bound to pontifical knowledge. The pontiffs knew the calendar of days on which legal business could be done. They kept the formal procedures and words needed to begin a lawsuit. If a citizen did not know the path into law, the path could be controlled by those who did. This does not mean ordinary Romans stood helpless before mystery. Early Roman legal procedures were oral, and many forms may have been familiar to adult male citizens, but precision mattered. The wrong words, the wrong procedure, the wrong day could defeat a claim. Written law did not make everything easy. It changed what law could be in public. It made some of the rules visible, an object that could be pointed to, remembered, and argued over. That is the setting of the 12 tables. In the Roman tradition, the ordinary magistracies were suspended, and a board of 10 men, the Decemviri, was appointed to write down the law. Decemviri means simply 10 men. Later accounts wrap the episode in political drama. A first board that writes 10 tables, a second board that turns tyrannical, a crisis that restores the republican offices. That tidy contrast of good and corrupt boards looks heavily shaped by later political thinking. The safer point is that Rome remembered codification as a crisis, a thing of law, office, and plebeian pressure together. The Roman tradition claimed also that envoys traveled to Athens to study the laws of Solon, the famous Athenian lawgiver. That journey is almost certainly fiction, a later attempt to join Rome's first great law code to the most prestigious Greek legal name available. But rejecting the Athens journey does not make Rome an island. Greek cities in southern Italy and Sicily stood far nearer than Athens, and city-states across the wider Mediterranean were writing laws, defining offices, and giving public procedure formal shape. Rome belonged to that broader world of institutional change. The 12 tables themselves must be described without exaggeration. They were not an early democratic constitution, not a Bill of Rights, not a generous social settlement. The surviving fragments hold very little constitutional law. They are mostly private law and procedure, the rights and duties of Roman citizens toward one another. That means summonses and court procedure, debt, injury, property, inheritance, the authority of the father, burial, the obligations of patron and client, and the ordinary disputes that make public order concrete. That narrowness can disappoint modern expectations, and it is exactly why the tables matter. A state is not made only of grand statements about freedom. It is made of rules: who can summon whom, who must answer, what counts as injury, what becomes of property, how inheritance runs, how debt is handled, how a dispute becomes a case. The 12 tables show Rome becoming more legible to itself through practical rules. They did not solve politics. They gave conflict a public legal form. The debt material in the tables is harsh. The code did not cancel debts after the manner remembered of Solon at Athens. It announced no mercy for the poor and dissolved no creditor's power. The debt provisions show a severe world: public declaration of debts, bonds, time allowed for settlement, and frightening consequences when settlement failed. Some of the most extreme clauses have been argued over by later and modern readers alike, above all the notorious language about creditors taking parts. There is no need to linger on that image. Its value is as evidence of legal severity and of social fear. That severity is the crucial thing. Written law did not arrive as kindness. It arrived as visibility, procedure, and form. A harsh rule displayed in public was still harsh. A debtor could still be in danger. A poor man could still need a patron. A creditor could still be the stronger. The point is that the law was no longer imagined as hidden entirely inside the memory and custody of the powerful. A citizen could now say that the rule existed outside one man's mouth. The bond of patron and client shows why public law did not end dependence. A patron was a stronger person who gave help, legal support, loans, and protection to clients of lower standing. In return, the clients owed loyalty, service, and support. The relationship could bind society together, and it could become exploitation. The 12 Tables even carried a severe religious sanction against a patron who wronged a client. The clause is revealing. Rome knew dependence existed. The law could name abuse. Naming abuse did not make social inequality disappear. The tables had a long afterlife besides. The original tablets were lost, probably in the Gallic sack of Rome in the early 4th century BC, and the text survives only through later quotation and summary. Yet later Romans treated the tables with extraordinary reverence. Schoolboys were said to have learned them by heart. Jurists discussed them as the ancestor of Roman civil law. By then many clauses were archaic, incomplete, or hard to understand. Their importance lay as much in memory as in daily use. Rome believed that its civil order had once been made visible in public writing. That memory changed the place of law in the Republic. Before the tables, legal knowledge could be pictured as a thing guarded by priestly and aristocratic specialists. After the tables, law was still formal, still difficult, still unequal in practice, but its public standing had changed. A citizen could imagine law as something the city had displayed, not simply something a powerful man announced. Set against equality, that is a modest gain. Set against what came before, it is a great gain in the making of a state. The long sequence after the tables stayed uneven. Tribunes became permanent actors in Roman politics. The plebeian council gained weight. Wealthy plebeians entered the ruling class in growing numbers. The old patrician monopoly weakened, and in time a new nobility formed from patrician and plebeian families alike that had held high office. For poorer citizens, the result was more limited. Debt, land hunger, patronage, and military service did not disappear. The Republic widened in some ways, while making new forms of elite partnership in others. That is why the Hortensian law of 287 BC should be handled with care. Later Romans treated it as the settlement that made plebiscites binding on all citizens and brought the struggle of the orders to its formal close. That was important. A plebeian assembly could now legislate for the whole community, but this was not democracy fulfilled. The rich still had their influence. The poor still carried social and economic weight on their backs. The tribunes themselves could become part of the political career system. Rome had made plebeian institutions public and powerful without making public life equal. The result is a more mature and still unequal republic. Liberty has moved beyond the simple rejection of kings. It now includes protection against magistrates, recognized plebeian officers, assemblies that can speak with force, and law displayed as a public object. Yet liberty remains unfinished, because different citizens meet the Republic from very different ground. A wealthy plebeian seeking office, a small farmer facing debt, an urban artisan needing legal help, and a patrician defending ancestral standing all live under the same Republic, and not on the same terms. This is the central answer. The Republic had to learn that a state without kings could still coerce, a magistrate could still overreach, a creditor could still ruin a household, a legal rule could still be hidden, an assembly could still weight some voices above others. The tribunes and the 12 tables did not remove those problems. They made Rome answer them in public. Before Rome could spread citizenship outward through roads, colonies, allied treaties, and the joining of Italy, it argued inward first over what citizenship meant inside the city. Was a citizen only a man who could be counted, taxed, summoned, and armed? Was he part of the people only when the state needed his service? Or could he demand protection, procedure, visible law, and officers who would stand between him and unchecked power? The Roman answer was never complete, and it was never pure equality, but it changed the republic. Debt forced the question of protection. Secession revealed the power of withdrawal. Tribunes gave the plebs officers whose work was intervention. Assemblies gave the citizen body organized voices, weighted and unequal though they were. The 12 tables made law visible, harsh as much of that law remained. Together, these changes taught Rome that liberty could not stop at hating kings. It had to become an argument over what the republic owed its citizens, in return for the service and obedience it demanded.